Come to order, please.
All right, we're back on. I don't see Mr. Sheffield. All right, just a heads up on the mics. It's come to my attention that these mics pick up sound pretty well. So if you are at council table, I suggest that those mics be pulled away if you're going to have a conversation with your client or co-counsel for that matter.
Thank you.
They are being picked up. All right, we're back on. So I'm trying to figure out the best way to work through the remainder. I'm thinking, given the time of the morning, that I'm going to focus on matters that involve witnesses who are waiting.
Yes, sir.
So I was just addressing what remains. I'm going to probably bounce around a little bit. I'm going to focus, given where we are in the morning, on matters that involve witnesses. So let me start doing that. At first, there's probably some witnesses that are waiting on this. We need to get addressed on the record. Matter that came up yesterday with regards to the mental health issues of Mr. Arbery. Spent some time last night and this morning working through this issue to try to figure out the best way to approach it. And let me tell you where I have landed on it. Well, first of all, one thing I didn't ask yesterday, and I normally do when we're in an area where it appears that it is either a first impression or limited case laws, whether or not either side has found any case law specific to the matter that the court could take a look at. So I'm going to ask that question. But what I'm also going to do is let you know how I'm going to proceed from this point forward on it. I'm going to bifurcate the matter. I'm going to ask that the defense tender in whatever documents that you have that you intend to use to present the issue to the court and to the jury. I'm going to seal those. The court is making a specific factual finding that given the fact that this appears to be a rather novel issue, because I have not found anything directly on point in Georgia, and the fact that it involves the mental health records of the victim in this case. The questions the court has about privilege 403, 404, 405, and maybe even 401, it would be appropriate for the court to go ahead and seal those records that are submitted for the court's review only. The closest thing I could come to finding on point for this issue is actually a Vermont case. And it is it's interesting because it's a case that actually was going to be remanded back down at the trial court because of a jury charge issue. And after the court had gone through its analysis of the jury charge issue, it brought up the fact that the trial court had reviewed the mental health records, or some mental health records, of the victim in that particular case, and it made a ruling. And the court ultimately, I guess if you look at the language, it looks like because the case was going to be remanded, the court requested the trial court to analyze that issue under a very general set of rules that the court had pulled together in Vermont. Now, a couple issues with this. One, I have not looked through the rules of evidence in Vermont. I do not know them, and I don't pretend to be an expert on them. But this opinion does address 401, 403, 404, 405, which tells me that they at least have a nomenclature close to ours, hopefully the language close to ours. The case also addresses a self-defense matter in Vermont. Looking at it, it does not look like the self-defense law in Vermont is exactly the same as Georgia, but at least it's a thing to come with. And I'm going to point the parties to this because what I'm going to ask to do after these documents have been submitted under seal is for the parties to brief the matter. And you can use the analysis in this case, or you can use whatever analysis you wish to use. I just would like from the parties their explanation of what evidentiary rules would permit this type of evidence to come in. And then you'll see in this case too, just the documents or just the records themselves aren't the issues. The records themselves contain a number of different types of evidence. So this court, of course, doesn't get to that analysis. It tells the trial court to go ahead and do it. But it says lay out the types of evidence within this universe of documents that you actually think you can get in and why. So I go through all that because I don't think this case, obviously it's a Vermont case, and so this is Georgia. It's helpful in the sense that maybe it provides a framework for this court because again, unless you all give me something this morning that's on point in the state of Georgia, this is now going to be the second novel matter the court is looking at within the last hour and a half. If I understand what I have explained, I'll give you the site. I guess I could do that. It's a Vermont case, State versus Bolaski.
I'm sorry, can you repeat that?
I'll spell it. Bolaski, Supreme Court of Vermont. It's a 2014 case, 95 Atlantic 3rd, 460. So again, it's helpful. May or may not ultimately be where the court goes with it. That depends upon those briefs that will be submitted as those within 20 days of today. An
Yes.
issue with that deadline from the state?
No, Your Honor, but I do have additional case law and some other things to present to the court today.
The issue with that deadline from the defense?
No, Your Honor.
As to the evidence that's going to be submitted under seal, Mr. Chevy.
Yes, Your Honor, you talked about documents. To reference, helps me have this up here because I think it can point us in the direction of where I'm headed. It will be records from the Department of Corrections that we have. That is the Department of Community Service, I apologize.
Department of Community Supervision.
Department of Community Supervision, the probation department that supervised Mr. Arbery and the 4-year relationship and the notes and thoughts and comments of the probation officer, as well as the statements being made by family to probation back and forth. So those are documents, yes. There will also be a 911 recorded call that the state agrees has been authenticated, but in terms of its relevance and all that, I understand the state wants to be heard on that. But we'll have a 911 call as well. We have all of the video evidence of Mr. Arbery in the community behaving in ways and interacting in ways that we feel, in addition to 404B relevance, it's relevant because it is thought and expression and behavior that we believe, our expert would say, is consistent with this diagnosis. So you'll have that, and I think you already have that. And we do have the medical records from Gateway. And we have the videos from within 220 Satilla that also shed some light. Satilla Drive, those are the intrinsic evidence in the case that we talked about that shed light. So we would want to be putting in video, audio, and documents.
Okay.
And then you have the testimony of our forensic expert to help draw the relevance down to February 23rd, 2020.
What I'd like to do is set up just if I can get those documents, if you put them on a flash drive and submit them to the court.
We have everything.
What I'll do, in fact, if you could.
Those are already labeled and on the flash drive that we have.
Yeah, I'm just trying to think of because I'm not here, and I'm trying to figure out how to logistically take care of this to review it.
Your Honor, if I may,
Yeah.
I would like to review what is given to the court. So I have an extra 32 gigabyte jump drive that we could use. We could put this on that jump drive, therefore it doesn't end up in the clerk's office with the other items on the defense jump drive.
Well, that's what I'm thinking, is that it may be better for you to submit that, Mr. Sheffield, to the court. I'll put a sealing order together. I've got it. And after I've had an opportunity to review it, then just seal everything into the record to the clerk.
No issue there, Your Honor.
So if we could just make the jump drive together, make sure the state knows what's on that jump drive.
We'll have a copy, another jump drive.
And then what we'll do for the record is ultimately what the court has received from Mr. Sheffield will be sealed into the record in that order.
Very good.
Okay. Okay.
I also have a response to the court's statement about cases, so it's the state's
Okay, actually, it's
motion.
Yeah, it's interesting. Your response state's motion, so technically the state. Go ahead.
Thank you, Your Honor. So the first thing I want to let the court know is that the way these,
Something just occurred to me as you're saying this. With regard to the documents, there was reference yesterday to a waiver for DCS. DCS. Is that a document? Is that a video or what?
Yes,
what was
it's
that?
on video through a body cam of the supervision officer saying, I want you to get a mental evaluation, please sign these records to release the evaluation to us. That's on one of the videos.
Do those records exist? Does that release exist?
I don't have a paper copy of the release, but I see it on the video where it says Gateway Behavioral Health System, and we see Mr. Arbery sign the document. It will be on one of the videos submitted to the court in December of 2018. I'm sure, well, I'm not sure. Gateway may have it, and so perhaps another subpoena to Gateway to make sure that we have all the documents.
It's not contained in the records from Gateway that currently exist?
I don't believe so, but I'll double check, Your Honor, and make sure. Yeah, I don't think it's there. We have an authentication, but not the waiver issue there.
Sorry, didn't mean to interrupt. Go ahead.
no, Judge, that's an excellent starting point. The state's position on any waiver by Mr. Ahmaud Arbery is that it was for a specific purpose. He is on probation. His probation officer has said to him, I want you to have a mental health evaluation. So it's now state action. It's court ordered. It's been released back to the state as part of his probation. That does not waive any privilege that he has, because you can waive a specific privilege, meaning that privilege for this specific purpose, not for this particular purpose. So back to how this came about. When this incident first took place, the coroner's office of Glenn County went ahead and issued a subpoena for the production of the discharge for Mr. Arbery's mental health records. So at that point in time, the coroner's office went ahead and did a subpoena, and Gateway provided a 3-page report, which was just a discharge summary, and handed that over, and it became part of the Glenn County police report. So that's how that happened. In an effort to make sure that we had everything, Special Agent Richard Dial went ahead and then subpoenaed all of the Gateway records out of an abundance of caution, and he received those. Those were made part of the GBI file, and they were therefore served on the defense. The reason I bring all of this up is because when we look at the statutes that are involved in this specific incident. We have and of course, I pulled them all up this morning, and now my document with that is, there it is. First off, we have 24.5.501. That covers certain communications that are privileged. We have Section 7, which is communications between a licensed clinical social worker, a clinical nurse specialist in psychiatric mental health, licensed marriage and family therapist, or licensed professional counselor and patient. The statute says there are certain admissions and communications excluded from evidence on grounds of public policy, including but not limited to the following. We also have number 5, which is communications between a psychiatrist and a patient. There is going to be no evidence that any medical doctor or psychiatrist actually saw Mr. Arbery. And then we have communications between a licensed psychologist and patient, but unfortunately under that Section 6, we also have no evidence he was seen by a licensed psychologist. What we have from the records that you will be able to review is that he was seen by a registered nurse or a nurse practitioner, and that is as far as the evaluation went. Obviously, this is privileged and therefore inadmissible on the face. However, we then go down to 24.12.11. 24.12.11 covers the disclosure of medical records and the effect on confidential or privileged character thereof. And so what we have right there is the disclosure of confidential or privileged medical matter constituting all or part of a record kept by a healthcare facility, a nurse or physician, which of course would cover the gateway records, pursuant to laws requiring disclosure or pursuant to a limited consent to disclosure. Once again, that's important. Limited consent to disclosure shall not serve to destroy or in any way abridge the confidential or privileged character thereof, except for the purpose for which such disclosure was made. So, coming back to the defense, they're claiming, well, he signed away his privilege. Well, he didn't universally sign away his privilege. It was for disclosure, for gateway, back to his probation officer. And this was all to help Mr. Arbery. It's now being used against him. In this statute, there is no way that he waived any sort of privilege because, pursuant to a limited consent to disclosure, shall not serve to destroy or abridge the confidential or privileged character of his mental health records. So therefore, the defense can't get at them that way either. And we have 24.12.1, and that brings me back to how these records were disclosed. 24.12.1 really covers all the other kinds of cases that we're used to. We all know that in an aggravated assault case where a woman's jaw is broken, or in an aggravated battery case where someone has been stabbed and they're scarred, their medical records become part of the case because that actually is an element the state must prove at trial. And therefore, 24.12.1 covers that particular instance. So they're obtainable by an appropriate court order or subpoena, and that is how we got the gateway records into discovery. However, provided further that the privilege shall be waived to the extent that the patient places his or her care and treatment or the nature and extent of his or her injuries at issue in the judicial proceedings. There is no way, absolutely no way, that Mr. Arbery has placed his mental health at issue in these proceedings where the issue is citizen's arrest and their claim of self-defense. So therefore, while we obtained the records, obtaining the records and handing them over does not in any way waive any sort of privilege for it to be used at trial based on 24.12.1. Now, of course, there's a number of cases, and the main case in the state of Georgia is going to be the Bobo case. So what we have with this is that basically in Bobo, B-O-B-O, versus the state, which is 256 Georgia 357, it's a 1986 case. 4 justices of the Supreme Court did not agree that the psychiatrist-patient privilege could be abrogated by a showing of necessity. The other justices said, well, you know what? If the criminal defendants show the court that it's absolutely necessary for their defense and there's no other way to get that evidence in, then, okay, we're going to go ahead and allow it. And this was 1986. That decision is a plurality opinion holding that the statutory psychiatrist-patient evidentiary privilege must yield to a criminal defendant's constitutional right of confrontation, but only upon a showing of necessity. That is, that the evidence in question is critical to his defense. The state's contention is they're claiming self-defense against a man they did not know, a man who they saw running down the street. We've got about a 10-minute incident. Mr. Arbery says absolutely nothing during that entire 10 minutes. So when they say, I was acting reasonably, that has absolutely nothing to do with Mr. Arbery's mental health. It is not critical to their defense. And they also then have to show that substantially similar evidence is otherwise unavailable to him. We contend that substantially similar evidence is completely irrelevant because it's not relevant to this case or the issues in this case. And there's a number of cases that talk about this and cite to Bobo. However, when you do a Lexis search, the number of cases that actually cite to the Bobo case from 1986, there's only about 30 of them. And in most of those cases, the defense is trying to say that usually the female sexual assault victim is crazy, and it goes to her credibility. And they want to bring in the mental health records to show that she's nuts and she's making this all up and I didn't, assault her, I didn't rape her, I didn't molest the child. That's usually these kinds of cases. And I think there's about 30 of them out there for the court to look at, just doing a Lexis search citing to Bobo in the state of Georgia. The ones that I could find that were of interest were first off Brown versus the state, 288 Georgia 364, which is a 2010 case. And at that point in time, the court did exactly what you're doing. The court said, okay, I'm going to do an in-camera inspection on these records. But at that time, the court was looking for any material which was exculpatory or which would impeach the complaining sexual assault victim's credibility. And the court basically ruled there was nothing there. So that was that particular case. Then we have Easter versus the state, 322 Georgia Appeals, 183, which is a 2013 case. And that was partially, hey, we want the records. And the court said, listen, you have to make a prima facie case that you can actually show that you need these records, that these records actually contain something. You can't do a fishing expedition just to go through someone's mental health records. And they said, our Supreme Court noted that the psychiatrist-patient privilege prohibits the defendant from engaging in a fishing expedition regarding a witness's consultations with a psychiatrist. Therefore, a defendant cannot explore such evidence unless he makes allegations sufficient to establish a prima facie need for its discovery. Unfortunately, they, of course, already have the records and now are attempting to use it. The most important case the state found on this is DiPietro versus the state. This is 356 Georgia Appeals, 539, and it is from September 3rd of last year, 2020, Court of Appeals case. In this particular case, the court actually here, and this was out of Fulton County, the court conducted a preliminary hearing to determine the admissibility of the minor victim's mental health at the time of her outcry that she'd been sexually assaulted, which the defense sought to introduce to undermine her credibility and the reliability of her account of the allegations. At that point in time, they, of course, cited to Brown versus Howard, 334 Georgia App, 182.
All right, everyone. Jake Wallace here from the WTOC Digital Desk at our newsroom in Savannah. I wanted to come in very briefly and let you know that we will be going off the air of this live feed if you were watching on the WTOC app or on your phone or on one of our streaming devices, so you can catch the news at noon here in just a few minutes. If you're watching this stream on Facebook or one of our social media feeds, that will continue. So we will continue this stream over on social media. Those of you watching on the WTOC app or on your phone or on a streaming device, you will be joining The News at Noon when that gets started here in just a few minutes. Thanks, everyone.
Appeals 511 at 2019. With respect to waiver, Georgia law provides that the mental health privilege is held only by the patient, and therefore only the patient may waive it. Newman versus the state. 297, Georgia 501, 2015. Here we have absolutely no waiver for this purpose. And until we see the waiver of what he was actually waiving, it may not be for any purpose except to inform his probation officer about his progress. In this particular DiPietro case, of course, the trial court ultimately ruled that the doctor could not testify to the impact of the victim's mental health conditions based on the documents as to her credibility of her outcry against the defendant because the expert's conclusions lacked sufficient probative value and thus were inadmissible under 403. Obviously, we are not there yet, but my concern is that Mr. Sheffield just told the court that one of the things he wanted was to put his doctor up in order to have you listen to her as part of the ongoing sealed sort of package. The state would object to her at this point testifying, given we're bifurcating this issue. So the court, though, however, the state wishes the court to be aware that 403 analysis is an appropriate analysis to conduct, because in this case, the court said, because of the rather raggedy patchwork of sources that the person had to deal with, I will direct the court to the raggedy patchwork of sources. These sources are Mr. Arbery's worst days of his life. Absolutely the worst days of his life when he is involved in law enforcement. This is not every day of his life. And to have their doctor come in and go, well, I looked at all this stuff and it supports a conclusion based on a 2-hour form that got filled out as a diagnosis, the state contends that's a raggedy patchwork of sources that their doctor had to work with because their doctor never ever met Mr. Arbery and never talked to him on his best day. And in addition, the court went on, it was not necessary to undermine the credibility of the victim. I understand that's not the purpose that they're doing this for. However, it is kind of the purpose they're doing it for. This is propensity evidence. They have said it's propensity evidence. They said, well, he's got a diagnosis and it makes him angry and it makes him, emotional. And therefore, he must have been angry and emotional, and therefore, this is how he reacted that day. All of which is speculation, and all of it is propensity evidence, which is not allowed. And Judge, that is the basis for why we ask that you deny this, and we will, of course, brief this and put all of this together for you in the brief. All right. Thank you, Your Honor.
Shepard. Thank you, Judge.
I'd like to first aid the court in what the court has decided about bringing records into its custody. And to say that we're talking about access, can we have access to these records, first of all? Can the defense have access to privileged records? And the statutes that have been cited by the state are the statutes that says these records are privileged. But the cases that I'm going to give Your Honor lay out very clearly that where the defense asks to have access to these records, there's a process for doing it. And it's to involve the court. And it's to have the court conduct in-camera inspection to determine if there's anything in the records that's relevant. So the idea of how do we do this and what the court has now decided this morning, that is a way to do it. And so our complying with that is consistent with the case that you just heard of, which is the Bobo case, which really laid out the framework. I don't know if the court was aware of the Bobo case before, okay. But that's where we turn it all over to you. But the Bobo case also says, we're not turning records over to the judge to have the judge review the records because psychological records are inadmissible or the facts and data contained within psychological records are inadmissible. The judge has to decide that. So I want to point out a couple of cases and get to the heart of it. We're talking about constitutional rights and the way that the Supreme Court and the Court of Appeals have interpreted constitutional rights and that interplay with the statutory protected rights. And so the Sixth Amendment confrontation is not just confrontation of a witness on the stand for purposes of credibility, it is to confront the state's case against the defendant and to confront it with relevant evidence that speaks to the defense and the central issues in the case. So the state is citing cases to you under the umbrella of relevance to say, well, there's a lot of cases where you can attack the credibility of the witness. We're not talking about that. We are so far moved past that issue. You're hearing it now from me. It's not about the credibility of Ahmaud Arbery. And it is okay to recognize and celebrate who Ahmaud Arbery was in 2012 when he graduated high school, but it is reckless to disregard the mental health illness that plagued him for 8 years leading up to this moment in February 23rd, 2020. If you look at, and I'll cite these cases to you, records like juvenile court records, that issue has been handled. Those are privileged records, but those give way under the Davidson versus State case here in Georgia, Pennsylvania versus Ritchie, which is U.S. Constitution case. Those are juvenile court records. School records, FERPA, subpoena, all that gives way to the private information in school records. And then you move to evidence of mental illness, psychiatric, psychological, and or treatment records. And Donaldson versus the state, when we're talking about access and privilege, Donaldson versus the state, 192 Georgia App 37, holds psychological medical records are not absolutely privileged. A blanket denial of records is improper, as all psychiatric records contain more information than merely the statements made by the patient to the therapist. Now, they do go on to say that some of those communications may be protected, but the diagnosis and the dates of those diagnoses and the medication that was prescribed, that type of information can come out of those records and be used for relevant purposes. So the protection is, we are going to protect people's rights to communicate openly and freely about their problems. But that doesn't mean we can't learn what was decided and determined based on those communications and what diagnosis came and then how it impacts the person. I'm just speaking right now to the statement by the state that pursuant to 245501, pursuant to 244411, that psychological records are inadmissible. That is a fundamental misstatement of the way our courts have interpreted the privilege in line with the Sixth Amendment of the Constitution and a defendant's right to confront. Yes, there's a privilege, but that analysis and interpretation flies in the face of all of the cases that say you can have access. Bobo Case says this: while the privilege should be given the utmost deference, when the privilege of a witness stands in the way of the defendant's right to confront the witnesses against him, then upon a proper showing by the defendant, the balance must be tipped in favor of his constitutional rights and the search for the truth. It says further, in order to abrogate the psychiatrist-patient privilege, the defendant must make a necessity showing that the evidence in question is critical to his defense and that substantially similar evidence is otherwise unavailable. We don't have to have our experts say what the records are, but it's important to note that on the timeline of his life, Mr. Arbery's life, that he had a diagnosis, that he was exhibiting certain behavior and certain conduct because it fits within the quality of the opinion of the expert and how it is relevant. So if you want to protect some of the speech that he gave, the witness doesn't have to share the speech. But it informs the expert's opinion and the quality and the credibility of that opinion to the jury. So we can use the records in a way that are permissible upon the showing of necessity. And while there are anecdotal accounts that the state has chosen to get into the mind of Ahmaud Arbery suddenly and say, well, these are just his bad days. These are just his days over the course of 3 years, which shows a very sad decline based on mental illness. And because he has had this decline in the presence of cameras and other people, then it's been captured. And then of course we should use it to analyze whether it fits within this idea of mental illness and relevance. It would be error not to consider this evidence because it comes from reliable sources, well-meaning people who are either trying to do their job or protect their community and have an interaction with Mr. Arbery. And so when we look at this, whether it's his mom or whether it's his community service officer or supervision officer, it is certainly the most quality of evidence that exists for this purpose. I also want to tell you the case of Lindstrom. Lindstrom, U.S. v. Lindstrom, Lindstrom, that is an 11th Circuit case. And Lindstrom was about a witness's mental illness who testified. The issue in Lindstrom was that the defense wanted to point out that this particular witness had a mental illness that caused her to have behavior, that caused her to do things that was relevant to the defendant's defense. And in Lindstrom, the court said, it is an abuse of discretion to preclude defense counsel from obtaining relevant information. The witness's privacy must yield to the paramount right to the defense, and in that case it was to cross-examine the witness. We're not going to cross-examine Mr. Arbery, but this evidence is of paramount importance to the defense, and just like in Lindstrom, it's about access to evidence of mental illness. In the Lindstrom case, most specifically, the court concluded, we hold that the jury was denied evidence necessary for it to make an informed decision. If the court recalls, I've been talking a lot about the decision that the jury has to make. The decision about whether or not Travis McMichael's interpretation of conduct that he was observing on that day, or what he was seeing that was odd about Mr. Arbery, was in fact necessary and relevant to his decision of how he had to defend himself that day. And so if you look at this statement, we hold that the jury was denied evidence necessary for it to make informed determination of whether the witness's testimony in that case was based on all the stuff that she testified about or whether it was the product of psychotic hallucination. In that case, the witness was a schizophrenic. The jury was denied any evidence on whether this key witness was a schizophrenic, what schizophrenia means, and whether it affects one's perceptions and external reality. The jury was denied any evidence of whether the witness was capable of distinguishing reality from hallucinations. Such denial was reversible error. So what we're saying here is that there, in the Lindstrom case, was a mental illness that caused misperception of reality, misperception of intentions, and it was relevant for the jury to hear it so that they could determine the defendant's side of the story and the defendant's defense. There's more. There are several cases, Your Honor, under Georgia law that deal with the impact of alcohol and drugs on a person's mental state and how it causes behavior. Very simply. Is there something going on in the system of the person that causes them to think and do and act in ways that's relevant to the determination of the issue? Crow versus the state is 277 Georgia 513. It's a Supreme Court case from 2004. And Crow says there was an expert in that case where the defendant driver got into a car accident with a woman. That woman was under the influence of drugs. And the defense offered it to try to suggest that the victim driver was under the influence of drugs, that it affected her conduct and behavior and her decision making. Whether she braked before the accident, whether she could have turned, did she act and behave in a way that was reckless on her part? And the court said it is for the jury to decide. The jury is entitled to hear all the relevant evidence, judging the credibility of the opposing witnesses, and make the decision for itself. So it begins to speak about, this is something that if we present to you that there is a relevant purpose, and that brings it now to the purview of the jury. In that case, the GBI expert said that the marijuana can...
Just so I understand it clearly, let's be very...
Sure.
honest. When you said it to the purview of the jury, you're talking about the issue, but now you're also talking about, we had a whole discussion, our whole presentation yesterday on 404B.
Yeah.
Okay. According to the rule, let's say hypothetically the court rules that the court does not permit the 404B evidence. In this way, it comes in anyway.
If the court does not allow it for 404B, what that means is the jury won't see it and then be instructed by the court that they may consider it for that purpose, for that limited purpose, if it tends to show the limited purpose for which it's been entered. However, the information also, because it is about thought and human behavior, it does shed light on the mental illness. Then the court would have to decide, is there a way to admit this evidence under a 403 balancing so that the issue can come before the jury but not be too prejudicial, right? So the court would say, well, we have an expert who could say, I've seen interactions with Mr. Arbery in the community or under certain circumstances where his behavior, there's a way to, I think, structure it, Your Honor, that you could, if your goal became keep 404B out because I don't think it satisfies the relevant purpose, but the mental illness, I believe, is relevant because the defense has shown me where it's relevant, then I have to figure out how to structure letting that evidence be a part of the presentation of the case in a way that's not prejudicial to the defense putting on its case, but also satisfies the state's objection that it's too prejudicial.
So next step, so then the court ends up with effectively a mini trial with the state and the defense arguing about what this evidence means, with the court then really just having the ability through a limiting instruction to inform the jury as to why they're doing all of this, or why y'all are doing all of this. That limiting instruction then would be a fascinating thing to put together.
I don't know that there is a limiting instruction on the use of evidence of mental illness.
Well, you put, follow me here.
Yes.
You got 404, again, hypothetically, 404B is not coming in. Limiting instruction, if it came in, you did the unlimited instruction. All of a sudden, they're getting other acts evidence in. I don't see any way to present these other acts and other acts through a different mechanism. I don't see any way, I would not be comfortable presenting that type of evidence to a jury without a limited instruction.
I understand.
Okay? So that limited instruction, I guess, is one. Two, and I just want to make sure that I'm clear, because I don't know, it's your argument, but I'm looking at both of you. I don't see how this issue gets to the jury without the state getting up and trying to counter that evidence. So I end up with a mini trial on the mental health issues that we're talking about here. Is there any way to avoid that?
Well, if the state chooses to counter the opinion, the court would first have to find that the mental illness has a relevancy. The court doesn't have to agree whether, okay, but the state would have the right. Yeah.
7403, I've got to work through 403, right?
Right.
So another thing I've got to work into this is what this little mini trial is going to look like in front of a jury, battle of experts over whatever this mental health diagnosis was in 2018, what that meant in 2020. And I'm going to have a battle of experts as far as I can tell, and you'll tell me if I'm going down the wrong path here, but I'm going to have a battle of experts in front of the jury in a murder trial about what the mental health records of the victim meant.
The state would have the right to counter our presentation, certainly, Judge. I would think they would. If they found that it was flawed and that it has no bearing on February 23rd, 2020, and they wanted to put up an expert to rebut that, I think they would have the right in the law to do that. Your Honor, it is easy and it is reasonable to say that this is an issue that could become a mini trial. But I think that often carries with it the idea that that's a negative thing that we should try to prevent from happening. We're not saying we want to inject a mini trial of another matter in this case. We're saying that it holds a special significance to the case.
Well, let's take a step back. I think that's all well good, but you know, one of the things that I think we need to really focus on when it comes to trying cases is the practicality of trying a case. And so all I want to know is whether or not that's an issue that I may face. I think it is.
Okay.
Because it's clear the state is going to counter the evidence. And I've got to work through what that all means. Let's just, because we can spend a lot of time just sort of walking through this. I think this would be much better to just go ahead and get down on paper, get it briefed to the court, so the court has an opportunity to digest it.
Understood.
Again, I'm giving you at least a little bit of an outline. I'm not saying this case, again, is the case that holds the key to all of this, but at least gives the court a framework to work off of. So again, I've got an idea on what I need to look at. I would appreciate particularly citing the cases that you have in Georgia, what the parties have, so I can go ahead and start digesting the issue and start putting together some thoughts and ideas on how we address this.
Yes, sir. May I inquire?
Yeah.
We're going to brief this on what I've kind of labeled as access. The court having access through taking the records. Would that also be helpful, or do you want us to go straight to relevance?
I think we should go straight to it. I'm taking the.
You're taking it. So the access is no longer an issue. Now it's about relevance. Okay. Then the other matter for Your Honor is.
Well, let me back up.
Yeah.
I'm taking the bid, so access for the court to initiate this process. I'm not going to do that.
Okay.
I do think the waiver issue is important. Okay.
Okay.
So I do want that briefed. I want to make sure I understand where these records came from and the party's position with regard to the waiver.
And we can probably agree that the reinstatement of the privilege by anybody that wants to reinstate the privilege on behalf of Mr. Arbery, maybe that's something that could take place, or that there's not a proper waiver by Mr. Arbery for these records to be used in court. We have to look at that document. If it says this waiver covers the use of the records in court, then maybe that resolves it in the court's mind. Irregardless of waiver, the court has the authority to abrogate the privilege. The other thing, Your Honor, is we have the need, and I think the right, to make a record about relevance from the perspective of the doctor and how it's relevant to the incident and the issues in this case. And my question of the court is, when will you allow us to do that? I think
That's the bifurcation.
that's the bifurcation. Okay. So are you saying that that is not going to happen today?
I want to go through the basic steps I'm saying. Bifurcation, the first part I want the law, I want cites, I want to know what the documents are exactly that are going to be used and how they fit within the evidence code.
Okay.
I understand generally where the defense is going to go with that from what I've been able to glean from yesterday and today. But we will get into more detail, I think, in a second setting if necessary in order to make sure that I'm very comfortable with exactly what's coming in. And that will give me some insight, I would think, on how this is going to be litigated by the state.
I understand. Very good.
Okay.
Let me make sure, if you would, just give me one moment. Okay, we all concur, we respect what the court is asking for. We want to help with that, and we'll provide it to you in the time that you've asked for.
I guess that's good to hear. Not sure how to respond to that. Yeah. All right. The discussion did bring up another matter that I do need to follow up on. I believe so. You had inquired about some records that were supposed to be under the defects.
Yes, I had done an ex parte motion, but it ended up, the order got filed, so no ex parte anymore. but-
Well, yeah, I mean, but I guess the won't be part of the record. But I will tell you, there was a inquiry in my office very soon after that order about the documents. And I need to look back and see if there's any, just follow back up on it, because I have not seen those documents.
Well, Mr. Chamberlain, and I'll find the email, he'll give me the date of when he dropped them off in Chatham County. And,
Just generally in Chatham County?
no, to your chambers is what I understood. I can check with Ms. Carney, I can find out who exactly he left them with, but he did comply with your order and the date and the order, and then contacted me and indicated, he just gave me, I think, the amount, the size that he thought it was, and that he had complied with the order, and that's where we were.
All right, well, maybe simply a question of them being placed in a special place somewhere in chambers. And I just have not seen them yet, so I'll have to find them.
All right.
It didn't occur to me until you inquired about it, and so I'll just have to look at those. But I'll
Thank
follow
you.
back up. All right. Let's go ahead then and address, Mr. Sheffield, you had one additional 404B witness.
He does. He just stepped out to let our expert, who's been here for 2 days, go, so she can get on the road. But we have the officer here who's prepared to report. I can go get him and tell him.
We'll go ahead and address that. That's not too bad.
And, Your Honor, I have found the email, just so that you're aware. It says January 15th, 2021 at 10:14 a.m. Record has been transmitted to the court. So I will follow up with him and
I'll see if I can answer that this morning, or we may have to follow back then.
Call Officer Yarborough, please. Maybe go right there.
You solemnly swear or affirm the testimony you shall give the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Please.
Morning, sir.
Officer Yarborough, where do you work?
Burke County Sheriff's Office,
How long have you worked there?
approximately 4 years.
4 years.
Yes, sir.
Okay. I've asked you to come here today to talk about an arrest that you made of Mr. Ahmaud Arbery. You understand that?
Yes, sir.
Okay. Do you recall that arrest?
I do.
Okay. When was that?
October 23rd, 2018.
Okay. I really want to whittle down to what the issue was that day, what your observations were of Mr. Arbery that day, and then I think we can kind of move on. Okay? All right. Do you recall what it was that brought you to make the arrest?
Yes, sir.
What happened?
The initial call, I got dispatched to possible trespassing with possible drug activity in an abandoned trailer. Upon arrival, spoke to the complainant, confirmed with her where the
complainant?
Sir,
Who was the complainant?
Miss Jackson.
And who is Miss Jackson in relation to this incident?
She was later identified as one of the 2 juveniles that was on scene as his mother.
Okay, so she called the police?
Yes, sir.
Okay. What happened next?
I confirmed with her what trailer it was. I walked to the rear of the trailer. There was an open door. I could hear voices, and
What did you hear in terms of voices?
I heard people laughing and cutting up.
Okay. What did you do?
I also smelled the odor of marijuana emitting from the trailer.
Okay.
I did notify dispatch, and she held the net as I made entry through the rear door by myself.
She held the what?
The radio traffic, all
Okay.
solely for me.
I see.
Made entry through the rear door. I saw one subject turn to look at me. I advised to let me see their hands. From there, they took flight out the front door.
Okay, let me stop you. Was that subject Mr. Arbery?
Yes, sir.
Did he make eye contact with you?
I could see him turn his head. I don't know if I didn't look at his eyes. I don't know if he.
Okay. What were you wearing that day?
I was wearing a short sleeve Class A uniform.
Does that have any kind of identifying marks on it that you're the police?
Yes, sir.
what?
Shoulder patches on each side, badge, and then collar brass as well.
Okay. Once you said, "Show me your hands," what happened?
I heard some shuffling and saw a light from the front door and noticed that they had all ran out the front door.
You said they. How many are they?
I did not see. I saw Mr. Arbery first, and then as I exited the rear of the trailer, I notified dispatch I was in foot pursuit. I then observed 3 total males running down Persimmon Drive.
Okay. Did you identify yourself as an officer?
I did as I was running.
What did you say?
I said, "Stop, police."
Did Mr. Arbery stop?
No, sir.
Okay. What happened next as it relates to Mr. Arbery?
I detained one subject. At that time, Deputy Clark came to assist me. He heard the radio traffic. He advised on the radio he had 2 black males walking back towards the incident location, and I advised him over the radio to detain them.
Did Mr. Arbery immediately comply with detention?
No, sir.
In what way?
It took multiple commands for them to get down on the ground, face down, so we could place handcuffs on them.
What were you doing when you told him multiple times to get down on the ground?
The other subject, Mr. Harrington, I believe was his name, I had unholstered my taser and activated it and pointed at Mr. Harrington and was giving him commands while Deputy Clark was commanding Mr. Arbery to get down.
And with your tasers and Deputy Clark's tasers pointed at the 2 individuals, one being Mr. Arbery, did they immediately comply?
Not at the very first command, no, sir.
How many commands did it take?
I'm not sure.
Can you guess?
Multiple.
Okay.
Maybe about 2 or 3.
All right. Did you notice anything about Mr. Arbery in terms of the way he was behaving or speaking to you during the course of commanding him to get on the ground?
I did not hear really what was said between Mr. Arbery and Deputy Clark.
Okay.
I was focused on Mr. Harrington.
Okay. Have you reviewed your body cam footage from that day?
Yes, sir.
And in reviewing your body cam footage, did it help you to remember what Mr. Arbery was saying during that time or how he was behaving?
Yes, sir.
And how was he behaving?
He advised, I could hear that he was telling Deputy Clark not to touch him multiple times. He was getting irate.
Getting irate. Okay. What about when he was being taken down to the ground? How was he behaving?
He got down on the ground himself.
Mhm.
He laid face down, then put his hands behind his back. I handcuffed Mr. Harrington, and then Deputy Clark advised Mr. Arbery to keep his hands behind his back, and he was placed in or detained from there.
And was Mr. Arbery irate at that point in time?
I don't remember. what he said at that time. I was more focused on Mr. Harrington.
Was he quiet? Was he belligerent? Was he any other way that you could observe?
After reviewing the body cam, he was loud.
Okay. Did you have evidence that Mr. Arbery at that point in time had committed a crime?
Yes, sir.
What crime was that?
Obstruction of investigation.
Okay. Did Mr. Arbery tell you whether he thought or not that he had committed that crime, or confront you or be confrontational about that in any way?
He advised that he was not the one running. He was coming from a gas station a few miles down the road and would deny any involvement.
Was he in fact the one running?
Yes, sir.
So was his statement to you the truth or a lie?
It was false.
False. Did you have opportunity to talk with him over the course of this arrest and putting him in police car as you were trying to figure out what was going on?
Deputy Clark escorted Mr. Arbery to the rear of his patrol vehicle. He then drove him back to the original incident location. After that, I was able to open the door and talk to Mr. Arbery. I got his name and his birthday, and I closed the door. I came back to talk to him and advise him of his Miranda rights prior to any questioning.
Did he understand those rights?
Yes, sir.
Okay. And did you observe anything else about his behavior once he was inside the police car, whether he stopped being loud or irate?
He still continued to be argumentative of the situation and contesting why we were placing him in, or detaining him and placing him in the rear of the vehicle.
Do you recall whether he said that he was just out jogging that day and that you had arrested him for no reason?
Yes, sir, he did.
Was that true?
No, sir.
Did you ever find any marijuana in the trailer, or anybody on the unit ever find any marijuana?
No, sir.
Okay. Was he charged with any kind of possession of marijuana?
No, sir.
Okay. What was ultimately the charge that he was charged with?
Misdemeanor obstruction of law enforcement officer.
Do you know if he ever went to court on that or went to trial on that?
I believe after speaking on the phone with you that he pleaded guilty to it.
Okay, so you now understand that he had a guilty plea.
Yes, sir.
You never went to court or trial
No, sir.
that you can recall?
No, sir.
Okay. Have you had an opportunity to look at the body cam videos from that day?
Yes, sir.
All right. Do you know how many there are?
I believe there's 3.
Okay, I've marked, just for the purposes of the mission at this time, and I'm not going to play them, Your Honor, but they're marked as Defense Exhibit 23, 24, and 25. I can say to the court they are the videos that we've gone over together. And so if you like a witness, I can put them up and play them so that he can identify them, but I've stayed in my place that they're the videos that were done on that day, if there's no objection.
There's no objection.
All right, then I move 23, 24, and 25 to deference, Your Honor.
Very good.
I just want to be clear on the record, these are his body cam videos. They're not Clark's body cam videos.
So they are his body cam and another officer's body cam, but I'd be admitting them because they fairly and accurately depict what happened on the day where he was present.
If you want the other body cam,
Sorry?
he's reviewed the other body cam?
Yes, he said he reviewed 3 of them.
Was he actually present at the time with the other officer?
Yes, sir.
We'll probably ask him.
For the purposes of this hearing, no objection to all 3, with the caveat, of course, that 2 of them are his and 1 of them is another officer who did not testify. So,
Good.
A moment, Your Honor. How long was the interaction that you had on that day from the time that you first encountered Mr. Arbery until your last conversation where you say he was still being irate and argumentative? About how much time had gone by, do you recall?
I don't. No, sir.
Is 30 minutes a rough estimate?
Approximately, yes, sir.
Nothing further, Your Honor.
Please do.
thank you, Judge. So, Deputy,
Yes, ma'am.
Deputy Yarborough. So misdemeanor obstruction, is that what he was charged with?
Yes, ma'am.
Okay, so you don't have any actual independent knowledge of what the disposition was in this case, do you?
No, sir. No,
No,
ma'am.
the defense attorney told you what it was, wasn't it?
Yes, ma'am.
Okay. And Deputy Clark, how was he dressed?
He had a Class B uniform on, which consists of black polo and green tactical pants with a black outer carrier vest, properly marked the sheriff's office on it.
Okay, and the body cam that you were wearing, was that the kind of like right here in your chest with the box?
Yes, ma'am.
Okay, is that what Officer or Deputy Clark also had on?
Yes, ma'am.
Okay. How many other officers were out there?
And initially, it was just me. Deputy Clark was the first responding officer. After we had placed them or detained them, I believe Sergeant Bars and Lieutenant Williams had arrived on scene as well, and Reserve Officer Reed.
So there were 5 deputy sheriffs out there?
Yes, ma'am.
Okay. I just want to make sure that there were 5 deputy sheriffs out there for a criminal trespass in a vacant trailer.
Yes, ma'am.
Okay. And what was the date of this?
I believe it was October 23rd of 2018.
2018. And were the other deputies there in full uniform as well?
Yes, ma'am.
And were they in marked patrol cars?
Yes, ma'am.
And so if anybody saw you, they'd know you were a law enforcement officer, right?
Yes, ma'am.
And you immediately identified yourself with stop police.
After they took flight, yes.
Okay, so when you first went in the trailer, what'd you say?
Let me see some hands.
Okay.
Referring to just to put their hands up.
Okay. And then they took off out the door,
Yes, ma'am.
and then you yelled, "Stop police."
Yes, ma'am.
So you identified yourself right away as a law enforcement officer.
Yes, ma'am.
I'm going to show you what's been marked as State's Exhibit number 41. I've already showed opposing counsel this. I know you haven't seen it before, but just go ahead and take a look at it, see if you're able to identify it.
Yes, ma'am. This is Persimmon Road where the incident happened.
Okay. Is it fair and accurate layout of that area on Persimmon Road?
Yes, ma'am.
At this time, the state would tender into evidence State's Exhibit 41.
No objection.
Submit.
All right. So we're taking a look at this. I'm going to hold it this way so the judge can kind of see it. Is this our vacant trailer down here at 125 Persimmon?
Yes.
Or is that where she called from?
I believe that's the complainant's address where she called from.
Okay, so then we got this thing. Is that the vacant trailer right adjacent to it?
Yes, ma'am.
Right, because you've been out there, you know.
Yes, ma'am.
All right. Now, if we walk up here, did you come to learn that Mr. Arbery, his grandmother lived at 158 Persimmon?
Yes, ma'am.
And that's, I mean, can you see the vacant trailer from Grandma's house?
Yes, ma'am.
Okay. Now, when you actually first encountered the first juvenile and talked to him, that was something different than when Mr. Arbery and Mr. Evan Harrington came back down the street. Is that right?
Yes, ma'am.
I'll go ahead and pass the witness. Thank you.
Yes, ma'am.
Just briefly,
Go ahead.
do you remember how old Mr. Arbery was on October 23rd, 2018?
24.
Okay, thank you. Nothing further.
Wow. And you've been released. Mr. Shepard, have you released?
Yes, Your Honor, thank you.
You can sit down, you are released.
Thank you, Deputy. I don't have any further witnesses on the floor.
We're closing evidence in forum.
Sounds right.
Your Honor, with the possible exception, if I may, with information that may be present in those defects records when they become available.
Hopefully, I will get some idea of what may be going on with that before we all depart today.
Very good, thank you. So we would ask that the record be left open in the event that we need to present those and add those in as well.
Yeah, I'm open to that. Let's just do it. Just want to keep track of what we have. But let's do this. It's closed. Go where an issue. Just move to reopen, referencing defects, unless there's some significant objection to doing that. Then I'll probably I'll go ahead and allow that based on the court's review.
Thank you.
Looks like we haven't sent it as a drive to the court. I have that as a drive.
Thank you.
All right, I think the time-wise, on the statement of Mr. Bryan, not Mr. Bryan, Mr. Bryan, we have one witness. I'm just trying to work out from one standpoint. Maybe best to break for lunch before we do that.
Well, yes, Your Honor, we have agency press, and I reviewed the length of the audio statements that are in question here. The first one is 2 hours long. The second one is an hour and 15 minutes, and then the last one is 8 minutes long. I have transcripts for sections 2 and 3, and I told Mr. Goff all about that, and that is what we were going to tender. I do not have from Mr. Goff specificity as to where in these motions or where in these conversations in the audio with Mr. Bryan his complaint of hope of benefit or fear of threat. So I'm going to tender them in. I believe that would help the court, and I'm sure Mr. Goff will pinpoint us to where it needs to be played.
Your Honor, I haven't seen the transcripts. I'm not complaining. If we could take a lunch break and I could maybe get a paper copy of the transcripts?
I do not have any paper copies of these transcripts. They were emailed to me after I'd already arrived here, so I have no paper copies of the transcripts. I have them electronically. I can email them to you.
If you will email them to me, I'll try and review them electronically over the lunch break. I have the benefit, Your Honor, of having been present for these interviews, but they're still rather long. But I think we would be ready this afternoon to address that, and I prefer to go ahead and get that out of the way.
Yeah, let me see how we're going to do it for a minute. Is the plan to play the whole statement, or are we narrowing down to the parts that are at issue? Or is it something the court can review in camera based upon the evidence that gets presented? How are we going to do this?
I would suggest that the exhibits be tendered and that the court be able to review them as the court deems appropriate, and we can point out by briefs the relevant portions thereof and do it that way. Because of the length of them, I mean, there's different views. A lot of judges want to see the whole statement before making a ruling. A lot of judges don't. In this case, I'm guessing you're going to actually want to review the actual statement.
And I'll tell you the way I normally handle it is I've taken the evidence, and if it's a long statement, generally I'll just ask that a copy of the statement be provided, and if there's no objection to the court reviewing the video or whatever it may be, after the evidence presented. The trick to that, though, is knowing what to look for. So that's not going to work if it's simply the court just needs to look at this and see whether or not there's something the court thinks may be inappropriate in there. That's really my question.
I believe that if the court gives us a reasonable period of time following today's hearing, I can identify any excerpts in particular that I want to address to the court. I think the issues in this case are beyond the content of the statements themselves. So it's worthwhile having the hearing. But I'm happy with the transcript being able to turn around and cite any particular portions of the transcript to the court. I know there's one excerpt in the second interview, about 20 seconds, that I'll be able to give the court. If I have a transcript, I give the court page numbers.
Yes, Your Honor. Based on Mr. Goff's brief to the court, he asserts that Agent Seacrest made promises. I'm going to put Agent Seacrest up to discuss those very things. So I believe that what Mr. Goff is trying to say is those promises by Agent Seacrest are not contained in the actual interviews that took place. They were outside that. So I think that's of course his assertions. So the burden, of course, is on me, so I have to put him up, even though they're the defendant's assertions.
So it sounds like there's no objection to proceeding with the agent today, with the evidence being tendered in, giving the court then the opportunity, it sounds like to the extent necessary, to review the full statement itself.
Correct.
And then the parties can go ahead and brief it so that we have everything before the court. Okay. So do we just then need, well, let's go ahead and break lunch. We'll do it right after lunch.
Thank you, Judge.
So it is 10 to 1. Let's plan on getting back at 1:45. Yeah, about an hour. 1:45. All right.
Thank you, Judge.
All right.